This is the Power 102 Digital Monday. On Mondays, Hard Talk, hosted by Karen Nunez. Tesheira is about to start right here and right now. We got a very special guest. Good afternoon, Karen. Hard Talk starts now.
Yes, good afternoon to you, David McIntyre, as usual. And of course, I don't even have to really introduce our special guest. All our guests are special, but I think he is very well known as one of two brothers from Tobago. Not that we are different, we are Trin Begonians. Dr. Vanis James, no stranger to anyone who lives in Trinidad or Tobago, couldn't possibly be. So before I go into the conversation that we're going to have today, which I have a feeling is going to be animated. Let's put it that way. Um, what I would like to say is good afternoon to all our listeners. There's a comment you can call in, and there's also a comment you can ask questions. We'd like to hear from you because this is a very important topic. Breaking down the Constitution and its importance, and I think Dr. James is going to do a good job of helping us with that. And look at that. I didn't even have to ask David. David, but just say the numbers out if you don't mind.
Yes, I will. The numbers that you can connect with us are 222-8255, and our toll-free number 866-525-1099. Toll-free 866-525-1099. We are also streaming live on YouTube and Facebook, and you can send your comments direct to the studio or to the show, and we'll read them out for you.
Yes, once of course you give us your permission to use your name because some people may not, like to stay anonymous. But before, let me just go on and say good afternoon, Dr. James.
Hello, Karen.
You're
How are
looking
you?
very, very serious, man. You're looking very studied to this afternoon. You have the weight of Tobago on your shoulders.
How are you doing?
I am doing fine, and I'm doing better, even better to have you on the show because let me just give, I always know that we should introduce you formally. I know you're no stranger, but I still think
Everyone knows me.
a little bit of that doesn't help, it doesn't do mischief. In fact, it does help. So we know that, and in fact, last time you were here, a lot of my understanding of your work, especially, I don't know if you remember our rather animated discussion about using medical tourism and how much work you all have done about 20 something years ago, went into different communities to get their feedback as to whether that was a possibility for Tobago. You were very, 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 very strong in it, as well as you were very strong in your opinion of the people you have running Tobago. So I don't forget our conversation at all. So let me just do the formal part. So Dr. Vanis James is a former senior policy advisor to the UNDP and WIPO, World Intellectual Property Organization. He's also been an international consultant. He served as a senior research fellow at the Scotiabank Chair in Entrepreneurship and Development and adjunct distinguished professor of economics and econometrics at the University of Technology, Jamaica. Author of 3 WIPO reports measuring the contribution of copyright-based industries to Jamaica and Trinidad and Tobago and the OCS. And I could go on and on, but that just gives you an understanding. We know also he has refereed journals and books in the main development problems of the Caribbean country, which I'm sure he's going to tell us some of our problems. And we're going to see through the eyes of the recommendations made by the committee that was set up, headed up by Mr. Sinanan, and then with very well-known and well-respected names included in the committee, and talking about the domestic capital sector is too small. We have a lot of nice language and high talking at a level, but I feel that I share a lot in common with you and in that regard. But today is about constitutional reform, and that's what we want to talk about because I think to a large extent, and I'm going to let you decide if you start with Tobago, because I did prepare myself for the Tobago first. So I don't know if we want to start with what the committee recommended, we the people, And your three basic ones that I could recall from your article in the Newsday that you felt that were not addressed. So we talk constitutional reform. There are a lot of big issues in it, but maybe we want to start a little bit on Tobago and some of the recommendations which they did make, which I thought were pretty okay, giving Tobago waters a definition and a number of things. So on to you. Give us your views of their work on the constitutional reform for Tobago and the recommendations that you added and why you added them. We could start with that.
Well, Karen, I suppose the basic place to start is with the question and the answer to what is Tobago and what is Trinidad. And the committee's report defines Tobago in terms of an 11-mile boundary around the island, but it doesn't define Trinidad in any such terms. It has a concept of Trinidad and Tobago and a concept of Tobago, but not a concept of Trinidad with boundaries. And that is immediately repudiated by the entire Tobago community and the experience of the people of Tobago. We need both islands properly defined in the Constitution. And that is why we recommend the use of a median line rather than 11-mile boundary, so that everything north of the median line is Tobago and everything south of the median line is Trinidad. Tobagonians know when they are going to Trinidad after they cross halfway coming down, they're in Trinidad. And Trinidadians know that when they're coming up, after they cross halfway coming up, they're in Tobago. And they're not, Trinidad is not all the way up north to Barbados. So, you got to divide the thing properly from the point of view of even what I might describe as natural rights, even that. But in any case, the median line is the appropriate boundary to use, and not any 11-mile or 6-mile as it obtains now in the law. So that's the first thing I think they failed on quite miserably, actually.
Why is
Secondly,
it important? Let me just ask, why is that so important? Because I'm being the agent provocateur then. I'm just asking really to elicit would someone not say that you taking that position, yes, it's given definition, but isn't it also going against the whole idea of one nation, one united nation, two countries made, but one nation, and by using this sort of physical division and telling me, well, when you cross you're no longer in Trinidad waters, but you're in Tobago waters. Is that going to be helpful, or why is that
the
important?
one nation principle is not affected in any way by that idea.
Okay.
We would still be one nation. You divide countries into units and regions and so on for internal purposes, primarily, uh, especially when you look around the world, for budgetary allocation purposes, especially in the context of the the responsibility that you will be allocating to the units defined for the purpose of uh, economic development, capital spending, and the exploitation in the case that we're describing here of the blue economy that's around Trinidad and the blue economy that's around Tobago. And Tobagonians, as I was pointing out, don't think that Tobago extends all the way down to the border of Venezuela. The country extends down there, but not Tobago. And it would be quite natural for Trinidadians to know that Trinidad does not extend up to Barbados. And so, for good governance reasons, good development, responsibility allocation, and so on, it makes a lot of sense. We have just been working, supervising, in the sense of overseeing being the chair of the Oversight Committee of a study that was being done on the fisheries industry of Tobago. And that part of our blue economy has turned out to be huge. I'm the second fisheries economist the country has ever had. And the kind of data that we saw collected in this study shocked even me as to the importance of that. Now, if you're going to have Tobago managing a Tobago fisheries and not managing the fisheries all the way down to Venezuela and the bottom of Pinal and so on, you've got to know what you're talking about. And it is in that sense, more than anything else, that you need to get proper definitions so you could talk about proper budgetary allocations to drive the development efforts of both Tobago and Trinidad.
Well, on that point too, yes, I did see that that has become a major issue, and it's a big issue in Africa now. Apparently, a lot of African countries have been complaining. Oh, that's not we are not dealing with Africa, but a similar idea or concept of perhaps being of lack of equity. Let me put it that way, because they're saying that in many of these African countries, if you were to quantify the value of the fisheries that are exploited by non-African countries, it's in the billions of dollars, and they need to now. It's become I shouldn't say a hot topic, but become a very topical, looking at the issue of the value of the fishing and fisheries in Africa. So I suppose the same can be said about Tobago. But I thought too, in asking you that question, that you probably would have mentioned the natural gas, because I think the committee did recognize that in the context of Tobago, there is value and considerable value under the seas, in the waters. And I assume they were talking about the natural gas potential of Tobago, so that when some may want to argue, what does Tobago do to deserve X percentage of the budget? What are they adding? What are they adding? Is that part of the discussion, the natural gas potential?
Not really. I mean, this is just part of the blue economy generally. The resources on the seafloor and under the soil is important, but it's not important to the dialogue about the boundaries, first of all. And it's in particular not relevant at all to the dialogue about the budgetary allocations. What matters for the budgetary allocations are the boundaries. When you get equal treatment of all citizens for the purpose of the recurrent budget allocation, what you get there will be a proportionality based on the population size. But when you're doing development budget allocations and you really want to talk about encouraging the Tobago community to pursue development on the national account and so on, you have to look, as you would see it elsewhere in the world, you have to look at the geographical space for which you're asking the local unit to take responsibility. And you normally average the population share and the share of the geographical space to come up with the appropriate formula for the budgetary allocations, which would then be subject to senatorial oversight, finalization if you have an elected Senate. We don't have an elected Senate, so our default argument would have to be about the budgetary allocations based on the population share and the share of the geographical space. That's why you have to allocate the boundaries. You have to define the boundaries properly so that you can say, take this share of the national development budget and go manage the development of this area of yours of our national space. And that's the logic. It has nothing to do with how much oil and gas you have there, because all of the revenues coming from whatever you're doing, whether it's oil and gas or fishing, comes into a national pool. And then what you do is you allocate the national pool on the recurrent budget fairly on the population share basis, so each citizen is treated equally. And on the development budget, you allocate taking into account the geographical space.
Yeah, but Dr. James, that is a very powerful and very persuasive argument. But the reality is that you know that many Trinidadians have even had a sedition legislation, sedition action brought against um, his deceased, his radio station and himself. And the point was that how he spoke of Tobagonians and in a most derisive and yeah, and I think he reflected the view of a lot of people that Tobago is what Tobago is there to go on as our little playground for Trinidad. Tobago, what does Tobago bring a value um, to the economy and the revenue of Trinidad and Tobago, and therefore your argument is very very solid. Then I hadn't heard it before. Maybe a lot of people have, but you've made it clear to me. You can't just talk about numbers because I think it's about 60,000 people in Jamaica in Tobago. If you're going to look at it by sheer numbers, then you're going to have a problem. But you have to also look at the what it means in terms of the geographical space and the developmental opportunities it represents, and then use those two equations, I guess, those two metrics, in terms of using, if I understand you, in coming up with a budgetary allocation. Can't simply be 60,000 people and it's not even the size of a good constituency in Trinidad, and whatever arguments have been used in the past. I think
Well, it can be 60,000 for the recurrent budget because each citizen has to have equal treatment under the law for the
right,
recurrent spending. But when you're
not
talking
enough.
development, it's a little
That's what I
different.
mean.
Yeah.
Right. I think I understand the point, but let me ask you what you thought, one, of the recommendations. Well, I have an idea, but I still want you to, what you thought of the recommendations of the committee. Very short, very brief, I have to say, if nothing less. And also to, that's one thing. And then your response, which you have given in relation to what you thought about even the consultation and the whole idea of the THA, how it should be reformed. You had much to say on those points. So could I hear what you think that anything good came out of the consultation and what should have been included in the consultation to be included in a reformed constitution?
Well, to grapple with that properly, you have to grapple with the composition of the committee itself. Uh,
I,
you're a jurist and you know that the country has a government which involves the entire parliament, the Senate, the House, the governor, the president, and the judicial. And if you look at this committee, it's a committee put together by the executive component of the government. So there is no role in the committee, nobody speaking for the judicial. There is nobody speaking for the opposition in the lower house. There is nobody speaking for the Senate, and there is of course nobody in there speaking for the Tobago House of Assembly, and so on. So if you look at it through those lenses, what you would expect is that this is a committee that is an executive operation, and it does not lend itself to any proper reflection of what Tobago thinks or what the local government bodies in Trinidad think or what the opposition thinks, right? Or what the judicial thinks. These are all parts of the government of Trinidad and Tobago. And to the extent that that is so, you couldn't expect much from the committee in terms of the positions of the constituencies that make up the elements that define the government. So when you look at this report, you don't see balanced representation of these various views. Nothing in the committee's report really speaks to what Tobago people want. Nothing serious. Nothing serious speaks to what the localities in Trinidad are really saying. And nothing at all speaks to what the opposition in the House thinks. So this committee was just badly designed and couldn't be expected to deliver much sense about what Tobago people want. Now, I went around Tobago as a researcher and inquired of Tobago's communities in the form of a set of focus groups, properly constituted research units, and identified, asked them, well, okay, given the way we built our Tobago economy, let me remind you, Karen, that our Tobago economy collapsed 140 years ago, exactly in 1884. We've never recovered. And what was kept alive was really kept alive by the communities of Tobago. Tobago is an island of community units, quite distinct. And those community units kept afloat the Tobago society while the export sector collapsed. So you really want to understand how Tobago is going to develop, you have to go to what those communities were doing. That's like you in Trinidad, that's where we invented our language, our music, or ways of treating with ourselves culturally and with strangers and so on. I might tell you, when I was a little boy, strangers took top priority coming into my village. When strangers come, you turn over your house to them essentially, and everybody else takes second place. That's the culture, and that was invented in the communities, along with our foods and all those other things. That's where Rose came from and Nelson came from, and all our music and so on. That's where Devon Stewart came from. If you look at all of Tobago properly, you will see that the thing that we kept alive as a Tobago, that was kept alive by the communities. So if you really want to know what you're going to do and where the leadership is going to come from to develop a Tobago economy that could contribute properly to the national economy, you have to go to the communities and find out. Let me just remind you too that
it's included in the constitution, because this is not an economic.
Yeah. No. I'm telling you, I'm talking about the constitution. I'm saying you have to go to them and find out what they in a constitution under which they will be governed. You cannot have a top-down arrangement to tell them what to want. As I asked Terry Farrell in Tobago on one of those sessions he held over there, do you want to tell Tobagonians what to want? You want Tobagonians to tell you what they want? That's the perspective you have to have. So you've got to go in the same way. You have to go to the units in Trinidad and find out they are the owners of the country. When all is said and done, everybody lives in a community. The citizens own the country, and all the citizens live in communities. And you're going to have to go to citizens properly constituted, and find out what they want. And you have to ask them proper questions. You can't just ask them, well, we're going to reform the constitution. What? So when you look at it through those lens, what you find is that what the communities told me, and I reported to this committee, is not at all reflected in it, because they say, well, you can't put communities in the constitution. But this same committee, Karen, says it wants to have every citizen having an economic right. Think about that. And what they do is they translate that into the right to belong to unions. Now, unions are just networking devices, as you know. So if you are thinking of us as workers, then that makes sense. But we're not only workers in the Tobago communities, because there we're doing business, we're organizing ourselves in other ways. And in those arrangements, you're looking at something that is much more important than our status as workers. Why not recognize our community rights, or rights to organize ourselves as communities as well?
In all fairness, though, I do think, which we haven't spoken to because we've stayed on Tobago up to now, this whole idea of proportional representation versus first past the post, and the idea that, at least half of the members, they should have a unicameral house rather than a divided house, like what they have in Ghana, a National Assembly. Not exactly what they have in Ghana, but a model which a lot of countries seem to be adopting, so that you get much more representation. And that representation would also include NGOs, would include a number of other groups that don't naturally fall into the political space. So in a sense, what you're saying, a community representation, that can be achieved through one of the things that this committee did recommend, or in terms of, is it time that we recognize that Trinidad cannot continue with the first past the post system. It's just simply unfair. It's simply not representative. It's simply contrary to everything that the preamble and the Constitution is supposed to stand for, when you have, and they actually gave some figures. I'm going off at the point, but I will go back to Tobago. Just let me just use an example they gave on that list, using a list system, or using a list system or direct voting system. And they said they gave an example where even where the PNM won out, and they gave, it said it's in 6 out of the 9 elections that the PNM won. This is in their report at page 2.42. It said in between 1991 and 2020, in which PNM won the election, they got less than 50% of the votes. And they said in 1981, UNR gained 22 votes and did not win a single seat. In 1986, the PNM got 32.3 votes, and they only got 3 out of the 36 seats. And anyway, the point I'm making is along the line, I hope, around this idea of community representation at the parliamentary level, where you have a voice to be heard, even though you're not running the country, you're not a member of parliament, you didn't win any, you didn't go up in national elections, but you are part of a parliament where you have a voice and where you can put real pressure and really be heard, and your voice be heard, because not only in terms of the way you go about the national elections, but apparently the way you also go about electing your president. I don't know if
that's not what Tobagonians are talking about at all. That we can come to the issue of proportional representation, but what they are saying is the way we are organized in our communities now is through these useless councils. And it is through those that we are asked in a place like Tobago to manage our communities, manage our business development, support all the things we want to do as communities. It is not enough, they are saying, to look at us as labor and workers for some private company or government. We are also people organized as communities, and instead of leaving us empty-handed with useless village councils, we want the right in the Constitution to organize our communities so that we are able to look after ourselves properly. From there, the people told me quite explicitly, they don't think the community development agenda of the Tobago House of Assembly is working for them.
Okay.
And it's not working for them because of the incompetence of the THA and the central government in understanding what they are able to do and what they can do. And they pointed out, they invent all sorts of things in the communities that the THA would interfere with and mash up. For example, the Blue Food Festival. Lance Tommy complained bitterly that they organized and developed the Blue Food Festival, and the THA intervened and now take it and mash it up. So they want the right to organize themselves as an economic unit, as a political unit, to ensure they could pursue community development. And they think that if they have that right, they will accelerate the development of the economy, continuing what they were doing ever since 1884.
And so, and you want that reflected, if I understand. But I think it's still, in my view, respectfully, you're talking about the communities of Tobago having developed in village communities, but you couldn't say that sitting about Trinidad?
No. Well, let me not say that. Let me say this. I asked the communities, every one of them in Tobago, what do you want to say to communities in Trinidad? And they said, let the communities in Trinidad speak for themselves. We think what we are saying might make sense for them, but it's not our business to tell them what to do. If they want to organize themselves as these massive agglomerates that you call local government units in Trinidad, that's fine. But they don't think that in Tobago that makes sense. So they're saying, you could learn something from us if you want, but it is for you in Trinidad to decide if what we are saying applies to you. But here in Tobago, what makes sense is we want to continue our development of our economy. We kept it alive for 140 years. It's not quite dead, but it's on life support. And we want the right to continue what we have been doing and make it a living, breathing, dynamic.
And therefore, that should be included into the
The
Constitution.
right to do it. You can't, the right to organize the community other than via village councils and all that useless stuff. They want the right to organize themselves. And they make another important point that you made.
For the purpose of?
For the purpose of managing their development, for the purpose of community, for the purpose of continuing the agenda of developing a Tobago economy. But they make another important point.
Sort of contravening, or when I say uncontravening, would it not be sort of be stepping on the toes of the THA, doing a duplication?
Well, they are the owners of the society. They think the THA is not helping them. They said so explicitly. I reported in the report I put together. The THA cannot be relied on to drive economic development in Tobago. We need a third force. We need the government at the Tobago level. We need the community organizations, the community enterprise, the community government, and we need the private sector. You have
we need that right to be included very clearly in the Constitution. Let me move on to
the right to organize themselves as communities, properly organized.
Yeah, because actually, to organize themselves in that way in order for developmental purposes. And I guess developmental purposes, a major part. Good afternoon, Mr. Prasad. He's one of my most loyal listeners, our loyal listeners, I should say. I hope, I am not here to platform at all, but I didn't see this included. This is more on a national level, talking about establishing a fiscal council under the Constitution. And it would have a specific role, which is to hold the government in terms of the budgetary process, to transparency, accountability, and fiscal management, and so on. And they also had another one, which I think Dr. Farrell was part of, and it fell apart in two twos. It was the Economic Advisory, establish an Economic Development Advisory Commission, which would give the government research national policy based on socio-economic research, and it sort of promote diversification of, and also the long-term development of Tobago. In other words, it seems to me the Tobago idea can be expanded out or fleshed out into something. What you're saying is the economic development of our twin islands, and you are saying to me that Tobago's development is unique to its own history, and that its mechanism for doing so is its right to do it through the village community methodology. But on a wider scale, we also have recommendation, because clearly something is wrong with how economy is going, that they need like what they have in America, the Federal Reserve, some oversight bodies, which is not the central bank, which seems to be beholden to the Minister of Finance, a little too much, one would think, as a fiscal council and an economic advisory board that is not up to the whim and fancy of the minister to hear and listen to what they have to say, or I've had enough of you, time for you to retire, or we get frustrated enough that you will. Apparently they did. I don't know if they got frustrated, but they certainly became a non-entity within a year. So I think it's along the same line. But I don't want to stick with the only Tobago. I want to give the 2 points that you made and then move on to the broader discussion. One of them is some of them are easy. The fixed election date. Another one is the referendum. Another one is the CCJ versus the Privy Council. Another one is no prime minister should serve more than 2 terms, consecutive terms. Those are, and then of course the role of an important one, I think too, is the role of the prime minister in the removal of any judge in the section 137 of the Constitution, where when it comes to the Chief Justice, it's up to the Prime Minister alone to decide whether or not a tribunal should be set up in order to determine whether there's a question to be answered. That's with the Chief Justice. And when it comes to the other judges, there's a suggestion that you should not have a Judicial Legal Service Commission, but a GSO And the Chief Justice would be a member, but you will also have somebody from the Law Association, a senior member of the Law Association, three senior judges, two of whom are retired. And so they're clearly putting in place something where the president, under the Constitution, although she acts in her discretion under certain areas, she still has to consult with this body. It will not be the prime minister, it will be the GSO. And so there are a lot of other issues that have come, which, and I think a big one is the existing law provision, which has affected us with the death penalty, affected us with the Bail Act, affected us in many ways that we don't realize until we're faced with it, because our constitution is so drafted. So there's so much more. But before I move on to those other areas, I noticed that in your article, or in the article, that you were quoted as saying a right of concurrence. Oh yes, and I think the committee did say, I would want to hear what you would have to say about that, that the Tobago should be allowed to make laws that affect Tobago, provided they are not in conflict with the national, national agenda or the national policy. That came from them. And what I understand came from you is that when they pass laws in Trinidad, that Tobago should have a right of concurrence, whether they agree or disagree with that law, and they should have that right to be have their views heard. So I would like to hear your views on the first thing, where they're saying that Tobago should be able to pass laws that are peculiar, unique to Tobago, with that caveat. And secondly, your point on the right of, I think it's concurrence is the term used. Then I want to move on to a bigger argument.
Well, if you don't get the design of the government right, all of those things would be sources of confusion. We've been talking for a long time in Tobago about the right to make law, local law. But we're not just talking about the right to make local law. What we're talking about really is the design of the government in Tobago in such a way that the people of Tobago can make law to ring fence the behavior of the executive council. We don't want a king in Tobago.
Mm-hmm.
And you may want to listen to that in relation to the nation and Trinidad.
Mm-hmm.
The cabinet operates like a kingdom there, and the executive council operates like a prince in Tobago, and we don't want that. So we want the people of Tobago to be able to make rules and laws to limit the excesses of the executive council here. And we recommend that same principle for the whole country. Now, to get that, you need a particular design of government. So the right to make law is no for Tobagonians. What's new is what design of government will allow that responsibility to be properly exercised on behalf of the people of Tobago and the nation. That design, this committee has said zero about. It doesn't understand the issue, really.
Well, okay, well then I have to say I reading too much into what they said and giving them more credit, because excuse me, I certainly am not partial in any way to the committee, nor am I against them either. So let me just make that clear, because I thought that one of the things that they recognized, and that they recognized that you could not take the Westminster model, which we did in 1962, and when you read the Wooding Committee report especially, you can understand why we had no Magna Carta, or we wanted a written constitution. We had no history, we had no jurisprudence, we had nothing really. So we transplanted what was easy and understandable and whatever, this separation of powers by the executive, legislative, and judiciary. The big difference which the Wooding Committee recognized, and this committee, I think, is trying to address in its own way, and which I think Ghana has tried to address, and I think the same thing will go for to Tobago, is that since the problem is that in Trinidad and Tobago, when you have the executive and legislative are one and the same. That's not true in England. In England, they limit the number of cabinet ministers to about, I think, 18 or less than that. I know 18 is the highest number. I'm almost sure about that. That they will not, and they prefer less than that. The Attorney General is not a cabinet minister, can only come and give advice and can go to cabinet meetings, but is not a member. But more importantly, the reason why can be this idea of separation of the executive and legislative is because there are 650 constituencies in England, quite apart from other arguments they put, the strength of their history, their media, they give you other thing. But if it's almost strictly the parliament, so that the prime minister has a limited number of his MPs who he can make cabinet ministers. That's one. And two, he has many more MPs sitting along in that parliament that are members of his party that can put enough pressure on him that he cannot operate in that executive way that our prime minister can in this country. In this country, when they win 41 seats, if they win 22 of the seats, they make all of them ministers or ministers in the ministry. So every single one of them who sits now in the legislature are members of the executive. There's no difference between them. In England, that's not the case. So one of the things I thought that they were trying to do to try to solve that problem, which Ghana has done, but I'm not saying there was a perfect model at all, is that to expand the parliament so that you would have, if it's, well, at the time I think Wooding had said 36 and then 36 plus 36, 72, but we know it will be 41 plus 41 using his model. So 41 of them would be elected MPs. The other 41 would not be elected MPs. They would be persons who would be members of the parliament, NGOs, union, different representatives within the parliament that have a voice in the parliament, and limit also the number of ministers, members of parliament that can be cabinet ministers, right? So I think they made a recommendation along that line, and I think that recommendation came from the idea that this this theory of separation of power between executive and legislative, yes, that's true in England. It's not true for us. And that is some way of limiting the number of cabinet ministers, and increasing the number by doubling and using what they call a list system, or inviting a number of different groups which to be formed part of this unicameral system. I thought that's what they were trying to do.
Well, may I say that, these slogans are not impressive in my view. What's important is understanding the critical arithmetic you need, and they got that wrong. They got the arithmetic wrong. Let me explain why.
Okay.
They didn't touch it at all for Tobago, which is an even bigger disaster. So you're going to design a government, give Tobago the responsibility to make law, and leave an autocratic structure in place that will just prevent development in Tobago forevermore. Now, in Trinidad, in the country as a whole, what they propose is that you have a cabinet of 18 and a lower house of 59. Okay. Now look at the arithmetic of that, and you would see the cabinet of 18 cannot be controlled by a lower house of 59. And the reason for that is you don't have enough non-executive members on the winning side, right, to control the cabinet. So if you have 18, how many non-executive members on the winning side you need? 30, somewhere there, to outvote the 18 on the winning side. That's 38.
No, as high as 18, That's as high as 18. I thought 18 was the highest number.
No. In the report they wrote, 18 is what they recommend. 17 plus the prime minister.
Okay.
Right.
Accept what you're
So
saying.
if you want to control the 18, say you need 30, that's 48 members already.
Right.
And then there is a maximum number of opposition that would go to that. So for the thing to work, 59, the arithmetic of 59, is impossible to get you oversight. You
Maybe
don't
that's
have enough
deliberate.
non-executive members, right, to allow for the government to function without turning itself over to the opposition. So if you understand that point, that's what you see in substance in Westminster. And in principle, you have to treat with that issue in Tobago, where we have this vulgar situation where the THA is almost completely executive with one opposition member and a councillor. You can't get any oversight out of that. So you need to deal with the issue in the design of government in Tobago. And you need to deal with the issue in the design of government in Trinidad, because if Trinidad is not properly organized and we are one nation, Tobago can't develop. So if Tobagonians want to tell you in Trinidad that we got to get the arithmetic right on both sides of the ocean if we want development in the country. If we want Tobago to develop, if we want Trinidad to develop, you've got to put an end to authoritarian government, and you've got to get the arithmetic right for that. Secondly, Tobagonians want to make it clear, and that's what my communities are saying. They want to make sure that the matter of the equality of status across the country, no unit left behind, no area left behind, no community left behind, and so on, has to be handled properly by a fully elected Senate. It cannot be handled by a Senate that is partly elected and partly appointed, because you need all the members in the elected Senate to be able to say, my constituents say. And the elected ones, like the ones you have now in Trinidad and Tobago, will not be able to say that.
A senator has a constituency.
What constituency? They are all appointed by a whole variety of people.
That's what I said, because you say that my constituents say, and
That's right. You need to elect a Senate that have members in the Senate, all of whom could say, my constituents say so, so, so. They need to be
like
able
in America.
to speak, like in the House of Representatives, in Trinidad and Tobago. You need to be able to speak to your responsibilities with the legitimacy of an elected representative. And that legitimacy cannot be achieved if you have 15 senators who are appointed variously by the prime minister and all sorts of stuff like that. So I think they got that arithmetic wrong as well. You need to elect the whole Senate and assign it a specific responsibility to ensure equality of access to development opportunity across the country. And that is done not only by the responsibilities assigned under the Constitution, but the particular responsibility for finalization of the development budget after applying an appropriate formula on spatial allocations. So these are not things that are strange to development economists like me. That's what we study every day in order to understand how countries must develop. But it's completely missing as an understanding from this document.
That's what I'm going to ask you. That's what I'm going to ask, because we can't just, I mean, as much as I love Tobago, we have people from both Trinidad and Tobago listening to us. And so from what you're saying, well, I'm not even want to try to influence what your point of view is, but I'm getting a particular perspective that document. What do you think of a document overall? Because I'm going to go to some definite things just now, but
we go to them.
Yeah. But I just, okay, let's do some simple ones. When I say simple, I don't think there's going to be too much argument with some of them.
But you understand my point. You got to get
the
basic arithmetic right, otherwise nothing else works.
Why? That's why I started by saying that. That's why I just said what I said, because I'm understanding what you're saying, and that is why I said let's do some little simple ones. Because what I was moving on to ask you is, so what do you really think about that document? Because I getting a sense of. Anyway, let me.
It's an executive council document. It's a cabinet document.
Yes,
it's not
that's what it is.
Not a negotiated position.
Yeah,
It cannot
they got
inform.
instructions. They got instructions and followed it.
Yeah, it's cabinet.
That is what, because now that you have explained it better, because to be more to be more what's the word fit accountable in what I'm saying. I know the idea of the number of MPs you have and the separation executive and legislative can't work in the context of the numbers that we have and the number of persons who sit in the parliament who are members of the cabinet. It can't, the separation just can't happen. And so this so-called attempt at creating this separation, now that you've explained it in more detail, I understand indirectly that one could say, well, look, they tried something. Let me go with some easy ones. Let me go with some easy ones because, it's so, it's really, we can make you very cynical. This is really the truth. Can make you really very, very cynical. One of the things, well, I don't think there's an argument about that, a fixed election date, as they have in the United States and most countries, the first Monday in November, because it's unfair. It adds fairness. It gets rid of arbitrariness and abusing your advantage when you think you're advantage to call elections, and it allows people to plan their affairs and all the good arguments. And they said that you should take into account things like whether school and universities are in the exams and those kinds of things. I don't think we would argue that a fixed election date is not a bad thing. Instead of a prime minister pulling out something out of his back pocket and saying you have any elections and having the country always on standby.
We've been calling for a fixed election date since me a little boy. So the country's been calling for a fixed election date since I was a little boy.
Okay, so right. But so they said it.
It's the right answer, and it was the right answer before this team.
Right. So, but we will give them that. The other thing they said is, I believe this is what they said, but I think Wooding committee said that when it comes to the prime minister, you shouldn't limit the terms. I think their position is, I am subject to correction because trying to find it, that their view was 2 consecutive terms, and then you take a cooling off 1 5-year period, and then you could go back in and try offer yourself as the prime minister. But either way, what is your view?
I don't find any merit at all in the argument about fixing the terms of anybody in the government. Whether you're talking about the Chief Justice or you're talking about the Prime Minister or anybody else. In a small society like this, you have to allow mechanisms of merit to drive what to achieve. Look at the trouble the Americans are having with a fixed 2-term rotation process. They have enormous trouble avoiding charlatans like Donald Trump from emerging as president. We saw it ever since the days of John F. Kennedy. You get terrible emerging options every round or two when you have this 2-year rotation, 2-term rotation.
I think 4 years I also think 4 years doesn't help because it seems as soon as they, in America anyhow, as soon as they finish the election, I know we have it to a large extent, but it looks like as soon as they come out of the election, they're into the next one already. I find, the 4 years.
I think the real threat is the emptiness of the successors. You're coming all the way from George Washington and Jefferson and them to Donald Trump. It doesn't make any sense. But if that's their problem in Trinidad and Tobago, the numbers.
It's our problem too,
No. My point is in Trinidad and Tobago, the pool you're drawing from,
yes,
is too limited for that constriction to make sense.
Yeah, but isn't there the fear or the concern, a reasonable concern, that if there are no restrictions on the number of terms, that you could be creating indirectly or unintentionally an executive dictatorship?
Not at all. If you design the government properly, there is no possibility of that's my point. You cannot set up the government badly and then limit the terms. You've got to set up the government properly. And that design is what is going to prevent autocracy and dictatorship. But if you have a cabinet of 18 in a parliament of 59, in a House of Representatives of 59, you're guaranteed dictatorship. So what is the point of limiting the term? It doesn't matter who you put, they'll operate as a dictator. You need a House of Representatives about 100 members if 18 is the cabinet. Otherwise, you have to cut the size of the cabinet.
Yeah, you have to.
To allow, right. If you're having 59, then the cabinet can be more than 10. And since that may not be feasible, you need to increase the number of reps. And the critical thing not to forget to deal with the issue of the emergence of a dictator is that when you allow for the genuine presence of non-elected representatives of the people dominating the lawmaking process, which is what would happen, not the cabinet, but the non-elected reps would dominate the lawmaking process, they become the most important members of the representatives, of the House of Representatives and of the Senate.
Yeah.
So you only keep this preoccupation with the executive that we have going on here with because we have an executive design in the government. That has to change. And if you change that, you don't worry about no dictatorship. People go to parliament to control the executive every day.
So you know where, anyway, I'll get to that. But okay, well, let me just say it then one time, as we on it. Well, what I gather, what I understand from what you're saying, which makes tremendous sense, and I'm sure, well, I'm pretty confident the level of intellect, I will assume, that converged to produce We the People, that they were quite well aware that that would be the outcome. So all of this is just smokes and mirrors.
Okay.
That's what I would know. This is what I would start to saying, because if if what you're saying is right, it really makes no difference whatsoever if the model that you are implementing allows for an executive control of the legislature. And if you continue with that, then you could have known terms, 1 term, 3 term, all those things. They matter not, because at the end of the day, and they must be aware of that. And so doing the easy things, honestly, doing the easy things that no one will argue is almost a form of, no, I don't know that, so but you are an intellectual, and I'm not an intellectual, but I would like to say I'm an academic, and I think I could analyze a little bit that doing that way is to distract you from what is, hoping that people won't catch on to the real issue, because once they don't catch on to the real issue and they say, yeah, we agree with this, yeah, we agree with that, yeah, we agree with that. Really agreeing with all those things matters not unless you address that, because it will continue to have what we have today, as you say, a king and a prince. So
I point to supplement your point with one important thing for you.
No, I only supplementing your point,
Yeah. but as a jurist, you would know. If you do not have an independent Senate, elected Senate, you really cannot protect the judiciary. The independence of the judiciary has to rest on the existence of an elected Senate that has the responsibility to protect the judiciary as part of its responsibilities, handling all those appointments and discipline and all that. You can't put that in the hands of the executive at all, because the executive is the enemy. So in that sense, failing to put a fully elected Senate also guarantees that the dictatorship of the cabinet will reach into the public service and reach into the judiciary. So you see what comes of getting the arithmetic wrong in the first place.
Yes, but then that brings us to then the president. I mean, all reading about these little changes they're going to make about the. What does it matter how you elect him? What does it matter really? Whether direct or using and the two methodologies that they put forward. But what does it matter if Section 80 says it's just to act on the advice of cabinet and a minister? What does it matter? What does it matter if every every appointment, including senior counsels, right? Senior counsels, I think that's right. Including senior counsels, including the Central Bank governor. Really and truly, she's just I'm not attacking the person personally. I'm talking about what the Constitution facilitates. And then, just let me just say this one thing: the current Constitution does say that there's area for her to act in or his own discretion. There's certain reasons, and it says so in Section 80. In his own discretion, and one of them, one of those bodies is Judicial Legal Service Commission. But then, who elected the president in the first place? Not the prime minister. And then it says that when the Judicial Legal Service Commission can appoint about 4 important Chief State Solicitors, Solicitor General, DPP, and number one in my mind is DPP. COP was once, I know they want to bring it back. They want to bring it back. They want to give back what the Prime Minister was so angry over, that change in 2006. I believe it was, I think it was 2006, if I'm not mistaken. I probably am, because 2006 we weren't in office. But the change that Mr. Manning brought when he said that for the Commissioner of Police and the Deputy Commissioner, there was an amendment to the Constitution that said those two positions, you had to do a merit list, and the merit list had to be given to the president, who would then prepare notification and go to the Prime Minister nearly had a heart attack when he was in Hansard, and when they were in opposition. He said before, the Prime Minister never had to do that. He'd sit down in the quiet of his office, and they'd bring him a name, and if he didn't like it, wouldn't to his liking, he'd take it and send it back. And they've done that. Their recommendation here is all the other ones, they're leaving them as it is, no longer called the Judicial Legal Service Commission, called the Judicial Service JSO, and the membership would be changed. It would be the Chief Justice and the member from the Law Association, and all this sort of thing. But at the end of the day, the power of veto remains with the president, with the prime minister, and most importantly, they are returning to him the power to veto the commissioner of police.
Well, you have to get rid of all of that nonsense. You are quite right. If you elect a proper Senate, a fully elected Senate, and you have the House make the nominations, whether the Prime Minister is involved or not, and maybe it's okay for the Prime Minister to be involved from the point of view of nominations from the lower house, all the appointments and all the discipline will be handled by a properly elected Senate competently. You pay them properly to do their job, and they have the responsibility to handle all of it. You don't need all of this run around and ring roading with commissions and all of that nonsense. What you do is get a properly elected Senate. It could handle all of the matters relating to appointments. Once it's properly constituted with its committees and so on, oversight committees, matching the oversight committees of the lower house. But if you don't have a properly elected Senate, then you have to tie yourself into all sorts of knots trying to deal with the issues you are raising. It can't be done. So you end up still with the nonsense we have going on. So you are quite right. Get rid of that whole junk, and let's set up a properly elected Senate and a properly structured House, and we're done.
But you know what though, Banners, that really, really struck me in my episode preparation when I saw their recommendation is to abandon the current position with the appointment of the Commissioner of Police and Deputy Commissioner. There's a big case, Andrew Thomas case. I'm sure you know that Andrew Thomas case. Very thing. He said you have to be very careful if you can have a runaway. They're not saying there is, but you could have a runaway prime minister that can make the police his own private army. And you have to, it's quoted extensively by many when they talk about the risk of commissions. And what I'm saying is the fact that you have recommending, like that, just as a matter of course, nobody arguing about the Chief State Solicitor, nobody arguing about the Solicitor General. That's not the argument, it's not about them. right? And the Attorney General already there in when Section 8, you have to have an Attorney General, and you have to have a Prime Minister to have a cabinet to run a country. But you slip in there the Commissioner of Police, a most contentious matter, a matter in which there is very strong feelings over the desire of the Prime Minister to control the Commissioner of Police, because under the legislation as it was amended, the Police Service Commission would be only responsible for the discipline, removal, etc., of the commissioner and deputy. Everybody falling under him would fall under the commissioner of police control. So he was given tremendous amount of power, and that taken away from the prime minister, which the prime minister Manning agreed to, and now they want to give it back and that was shocking to me, actually.
Well, neither the president nor the prime minister should have any business in that. The prime minister and the lower house, in whatever way they do it, make nominations. The Senate appoints. The Senate handles all of that. And that's what you have to do. The president shouldn't be appointing anybody. The prime minister shouldn't be appointing anybody. The prime minister should be put there to implement the law made by the non-executive majority and the opposition in the House. That's it. Yeah, no business appointing anybody and creating the challenge you're raising about a kingdom and autocracy and authoritarianism and dictatorship.
Oh Lord, I think that one really, I have to be honest with you. When I saw that, I said, what happened? They acting on instructions or what? The referendum issue, I think the general view, I don't know what your view is. I know a view, and I have to say, Hope had a view on that. They have to be careful with the use of a referendum. Obviously, it has to be of a matter of national importance to be able to do it in the first place. It's an opportunity between elections for people to have a say in a matter that affects them. And one of them would be joining the CCJ or staying with the Privy Council. And one of the arguments that's put forward, as Huber's put forward, is that perhaps two things can be done. I didn't think it was such a bad idea, because people are really concerned about letting go of the Privy Council, not because they think that our judges are not intellectually capable or competent, but because of the size of our country and the ability either to exercise favoritism or punishment, whichever way it is. It goes, and one of the suggestions was that matters that involve the government or government bodies should go straight to the CCJ. And then if the appeal would go to the Privy Council for a limited period, and depending on not only the decision, but the reasoning of the decision, that lack of confidence or the building of that confidence could be achieved. But at this stage, St. Vincent tried it, and they failed. It was a big failure for the Prime Minister. Antigua tried it, and they failed with the referendum to go to the Privy Council. And I think there's another country that did the same referendum. Well, Jamaica didn't want to try. They didn't want to find out. We don't want to find out. And they also say that if we do have a referendum, maybe we should have to be careful how high the marker is. What do you think about that? Referendum in general, referenda, and in particular with regard to the CCJ and the Privy Council?
Well, that's the reason I say you have to know how to construct the determination of our constitution via a negotiated process. Because when I went to the people of Tobago in my survey, albeit it's a survey, every community told me they want a judicial system that in which the jurists that might make decisions that might limit their rights must be the kinds of people who understand what we are trying to do to develop ourselves and our communities. And if we have those kinds of jurists, we will take a risk with that. Now, for them, they don't want nothing to do with any Privy Council. No. That no, I'm just telling you what the people at Tobago tell
I
me.
want to know what you think.
Well,
Mr.
well,
I
you know what?
want to know
I'm a
what you
born
think.
Democrat. If my people say they don't want no Privy Council, I go in with them. And I
You
am
need
not.
to do that, man. You
I
need to do
understand
that.
enough. I work in the international community enough to tell you, as a
Mm.
scholar in my profession, that the international scholars I work with are
Yeah.
no better and many times worse than the scholars I work with in the region.
I don't think
So,
anybody questioning their ability, you
so
know.
I don't think the Privy Council have any better capability than
No, but
regional
nobody,
judges,
but that's
CCJ
not
people,
fair.
and so on.
What do you think the fair is?
No,
Okay,
I know.
I'll read you something.
I
I'll
know.
read you something. I'll read you
Tiago
something.
said he wanted his justice from afar because
No, no,
of
no, no. I
fairness.
will give you. No, no, no. I'll give you a reason why. I understand. Let me not go into lecture on that, but let me just give you two examples why there may be a reason for persons when it comes to matters involving the state or state-owned enterprises. When you have a prime minister sending an email to the COP asking about a FUL certificate for his friend and saying he will pick it up. When you have illegal quarrying
But if you
done,
have oversight, that can happen.
who oversight in this country?
If you set up the government properly, you will
Wait,
have oversight, and you cannot. Then that cannot happen.
and you know what you just told me? You know what you told me? I think I heard you say. I think I heard you say that this idea of terms and limiting terms, we don't have the luxury of limiting terms because the pool of persons that would qualify in this tiny country of ours will not be sufficient. So we need to
But,
allow
but,
them.
but the issue is oversight. It's not term limits. If you have effective oversight in the lower house and in the Senate, you cannot have a prime minister writing any commissioner of police and instructing them on anything if that's against the law. The oversight mechanism will deal with that. So the prime minister's threat as a dictator is effectively limited by the presence of a properly structured parliament in which proper oversight can come from the lower house and from the Senate, an elected Senate. Once you have that, you don't have to worry about all these problems with abuse of power. And therefore, you can afford to get
Okay.
proper judges in place who know what we are about and what we're doing. And that's what the people of Tobago are saying. And
Okay.
they are also saying they want to have a say when the THA is making law, and they want to, that's what my communities are saying, and they want to have a say when the House of Representatives and the Senate in Trinidad making law. And
I
they
agree.
want them to be able to come down to the community and say, well, this is what we know, consider it. We still make our decisions in the communities, but they could come with the information. Everybody, one guy told me in Argyle, nobody blocks anybody's information. So all of us have access to the process of making rules and laws. And if that is true, you cannot have any prime minister abusing power in that way. So that, I think, is not a justification for keeping an archaic device like the Privy Council. In any case, my community said they don't want it, and I go in with them.
No. Vanas, can I read something to you then?
Yes.
Okay, there's two reasons why.
Yes.
And I have been very conflicted because I mean I am very much for us being independent of sovereignty and all that good stuff. I'm also a realist. And maybe badly, maybe it's a bad thing I'm also a lawyer and either taught or went to school with or know many of them. And you wouldn't like to hear my opinion. And it has nothing to do with their intellectual capacity. Okay, so that's the limited pool that we have in this country. Okay, so let me give you an example why I could have a fail. And I used it already, but I'll give you the one. It's a case that came out just in April of this year, where the DPP, the poor DPP, they're trying so hard to get rid of that DPP. They're trying every which way to get rid of that DPP because they want to exercise this control over. Because they can't control him because the Constitution gives him that, insulates him from that. So he had a murder case going on. And while the murder case was going on, the two of the accused went to the civil courts and asked for a judicial review of the decision of the DPP to pursue a murder case against them, whilst the matter had already started and was about to continue. Right? This is what they did. 3 judges. I'm going to call the name of the judges, but you could guess who one of them was. And it was a minority judgment by Beirut. So you guess the others. And this is what I'm only reading in the conclusion. That's all I'm going, because just have 2 paragraphs I have to read. Right? So I explain the background. They went and gone for judicial review in the civil court against the GPP, and the decision went to the High Court, MSC Court, and because of that decision, I think they were let go, because it was not the indictment was released or whatever against the 2 accused. But let me read what it actually says. Conclusion. This appeal arises out of an unfortunate sequence of events, commencing with the seeking and granting of leave to apply for judicial review on a without notice basis, meaning that they didn't tell the DPP. They didn't tell the DPP. They did not let the DPP know that they were having the hearing. That's just breach of natural justice. So don't tell me they don't know what they're doing. So they didn't, without notice basis. The board agrees with the decision of the minority, which was Justice Barrow, that leave to apply for judicial review should not have been sought or granted at all, let alone in the absence of the DPP. The criminal trial was due to restart within days and provided an adequate and effective alternative remedy for the respondents. There's a jury, there's a judge who does a summing up, and there's legislation. There's so many checks and balances, it isn't funny. It's important, this is the last thing, it is important for the courts to guard against the danger of unjustified collateral attacks on prosecutorial decisions, as the authorities confirm occasions when it is appropriate to judicially review a prosecutorial decision, whether to continue to prosecute are extremely rare, which is what Barrow said too. In the present case, there was unwarranted interference by a civil court of concurrent jurisdiction with ongoing proceedings in a criminal court. That is this year, that was a few months ago. Before that, you had a local government elections. I wish I brought that case with me here, because in that case, it's not so much the decision that they had no right to do what they did, which is to extend the term of the alderman and the councilman by another year without passing the legislation. They at least 6 times in the Privy Council decision, they said Trinidad has a democratic republic. It is not for the government or the parliament, much less the government, but for the electorate who elected them to decide, make that decision. That's the Privy Council. If we didn't have the Privy Council in those 2 cases, 1, they're trying to weaken the DPP, and 2, the government running roughshod over a major issue as local government election. So, and that is just a year or so ago. So I am very, very sorry. I have had a hard time with friends and, saying to support the Privy Council. Of course, I support our own CCJ. I do support it. There are lots of checks and balances, but the Caribbean is a very small place. I saw everybody, including you, Vanessa, I don't know, may have family in St. Vincent or Grenada, Antigua, it's so small. It's so small. I just gave you 2 cases. If they didn't have the Privy Council there, if they did not have the Privy Council there, what would be the thing? And that is not about inability or intellectual inability. And the other part, is not a lack of ability, it's a lack of trust.
Well, if you design a bad system,
oh God, you come back and tell me.
And there's one good element in the system, you get to say what you're saying, that the one good element might work. But what we have to do is design a full system, a proper system, Lord, in which you have the people's trust placed in their elected reps. That's where
answer those 2 things that I just told you.
Well, I'm answering you. If you design a terrible system that requires you to have a Privy Council, you're in big trouble. But if you design, why doesn't the British come to your Superior Court and ask them to settle their cases? Let me ask you that.
They
Why
don't.
don't they go to the American Supreme Court when they have
Oh,
trouble?
are you crazy?
Well, that's what I'm saying. You've got to
America,
sit
the
down and
American system, their Supreme Court is loaded with whoever government is
Well,
about.
but what I'm saying is you have to design a proper system if you want to treat it on the regional space. Fine. Let's design a proper system of government, a proper judiciary, all the checks and balances in terms of the oversight role, the lawmaking role of a properly constituted government. And then you give that a chance to evolve and get mastery and so on. It takes 1,000 years, but let's go. I don't see any basis on which I could say that Trinidad and Tobago should want to retain anything called a Privy Council. I hear you, but I think that's tied to an awful system that we are running today. Let's fix that, and then we'll see where we go from there. All
All
of us
right,
put in the shoulder.
and guess what? I totally agree with you because my only reservation, I have the highest regard for Adrian Saunders. I have a highest regard for many of the judges who make up the CCJ. Ghana, which has a similar kind of ethnic conundrum as we have the confidence of the CCJ a long time. They stopped going to the Privy Council since the 1970s. Dominica joined them. St. Lucia the other day, I understand it's by accident, but anyhow, St. Lucia, Barbados as part of it. So they have enough confidence in their own system. And the impact of it on the other side of the fence, and I'm going to leave that point at this point, because it really is coming back to systems and structures. That's what you're saying. Because an example of that would be, and I wish I had it with me. I do have the case. Or I don't have the case, but I have the quotation from the case. It is in that Chandler case where Nunez, the case in Barbados, when they joined. By the way, Belize was a member of the CCJ. I'm sorry, the Privy Council is the final court, and they also moved away from that, as did Barbados. And when Barbados did that, I mean, I'm going to quote, which is what you are saying and what your fellow Tobagonians, who you say you must follow. I only say what you tell me, huh? Right? This is what he said. The president of the Caribbean Court of Justice on the Nunez case is a murder case. So in all our jurisdictions, we all have the savings clause provision, which says that if there was a law in place prior to you becoming independent, even though it offends against your rights, your human rights in Section 4 and 5, in our case, Section 4, your rights, freedom of expression, all those enshrined rights, even though it does that, it's still good law unless you it's repealed and replaced with another law. So we still have, many of us, Trinidad included, still have on our law books the Summary Offences Act, the part that deals with the penalty for murder shall be death. Right? They don't mess around with it. And so because of that provision, and it was made before we became independent, we are bound by that legislation unless we change it, and we haven't. But some countries, because we still have this Privy Council as our final court of appeal, Barbados moved away, and this was a murder case, and this is what the President Byron had to say about us continuing to send matters to the Privy Council. And this was a murder case, and he said, at paragraph 58 of the decision, he said the general savings clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring, meaning a local court, our court, is prevented from declaring the truth of that inconsistency just because the laws formed part of the inherited laws from the colonial regime must be condemned. So that's your Tobago reasoning right there.
And we could find you a lot of eminent jurists in the country who hail from Tobago, who would respect the views of the people of Tobago and can be the people in which you repose full trust in the judiciary. The Tobago jurists, I could call their names,
No,
you know,
okay.
distinguished ones.
Okay, let me
I mean,
Banners, before you go and call names. I learned something. One thing I learned from me inside the belly of the beast. Don't ever think you know who good or who not good. Don't ever put your head on.
I'm telling you who Tobagonians will
Huh?
repose confidence in. I'm telling you who Tobagonians will repose their
Okay.
trust and confidence.
Tobagonians.
We
Right.
can't say what will happen in Trinidad. I don't speak for it out there, but
You only keep on with this. You see, you come and tell me, oh, the line don't really matter, but you keep on making distinction between Trinidad and Tobago. Go ahead. What did Tobagonians say?
I need to ask a question here. I'm seeing Mr. Montano is on the sort of
Yeah,
on the
this
same
over
page.
here.
With me. He said there should be a referendum to decide on the final court of appeal. Now, with all of this said and done, where constitution reform is concerned, tell me something. I understand deeply what Dr. James or Professor James is saying. I understand what Karen is saying also. I
Yeah.
listen to a lot of people who talk about it also. And I'm asking if we had to go about to have these changes done, what role will the people have to do or demand to institute these kind of changes? I mean, I too would appreciate very much if we have especially that oversight committee to make sure that checks and balances are kept in place. But how do we go about that process, Dr. James, as to 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 start or to initiate any of that form of systematic change where government is concerned?
well, on Wednesday in our session on this matter in the Scarborough Library, we made a recommendation in the light of the inaction of Farley and his team. Our recommendation was you have to do in Tobago properly the process of going to everybody in all the communities, you as the THA, that's our constituted government over here. Let's put a proper process in place so that proper questions can be posed to the citizens. And you do what I was doing in my survey research, and you hear what people have to say. And bring that together with the result of a similar process in the localities of Trinidad. Get all the voices down there to be heard. And then let's set up a process of negotiation. Just after you finish your negotiated process in Trinidad, we'll finish our negotiated process here in Tobago, and we will come with two sets of positions. What Tobagonians say they want and what Trinidadians say they want. We iron that out in public where everybody hearing and seeing what's going on, and at the end of the day, we have a basic start. To my mind, that will work just as well as anything you're calling referendum. And then we spend the next 2,000 years cleaning and fixing and cleaning and
But
fixing.
you'll have to have a formal thing, though. I mean, what he's asking, I understand what you're saying, but if you could answer him, and I'll be to also, because it's a very clear question he's asking, should there be a referendum for to decide on the final court of appeal? Should be who? Because countries have done it and it has failed. And so I understand what you're saying about the we have to have the consultation and extensive, intensive consultation. I understand all of that because
Proper
people have to,
hearing.
right, you've got to do that. I understand that. But at the end of the day, in the Constitution, should we put in the Constitution a provision that allows the government to hold a referendum on matters of national importance, and that they set a threshold as to, I guess, if 55%, whatever percent is necessary to say the referendum was passed or not. That is what I think you want.
My answer to that in straightforward terms is
Mhm.
You can use referenda for a few selected things because referenda are by their nature very clumsy things. You can have ballot initiatives, which is what elections are, referenda in their own way. You can have ballot initiatives, and the people will have their direct democracy mechanisms available through those things. People can then choose whatever ballot initiatives they want to put on the table for an election. You get a plebiscite, and we see what comes of that. But I am just suggesting that, from my experience as a data collector, uh, what you will get is a much, if you use carefully crafted hearings mechanisms, you'll get much more information, much better information, much more informed judgments from the very people you're talking to make any of these decisions. That's what I'm saying about setting up the thing in a way that allows everybody, a coalition of the willing, to come and say, this is what I think, this is what we think. Let's talk about it this way and so on. Everybody brings their papers, brings their comments, carefully crafted around the issues that we want to sort out. Out of that will come a Tobago position. And the same can be done in Trinidad. You don't have to shortcut it. You could bring the whole government into the process as well. You can do it in Trinidad and in Trinidad and Tobago for that matter, in a way that, I mean, let me ask you this, Karen. Why is there no representation of the jurists in the country, the judiciary in particular, not jurists, but the judiciary, in a committee of the kind that was put together? If you had them there, they will bring their wisdom. They know a lot about the law that many of us don't know. The same would be true up and down the place. So when you have properly constructed hearings before a competent committee or set of committees spread across the nation, what you will get will be informed views from citizens on any matter. I think you'll get better data from that, better information from that
And
than
then
you.
you have to have something formal, which there has to be a decision made, because you have to get, you can't just, in other words, what I'm saying, I understand completely, and I think you've answered Mr. Montano's question. If I think as what you're saying is a form of referendum. It's the same difference,
So
but not
it's a different format, yeah,
a
of,
format.
of
A
information collection, yeah,
more effective and more effective
absolutely,
and
more
more
efficient, yeah,
and
more
also more
informative.
inclusive and more inclusive.
That's correct. And then you go to the existing parliament. I mean, that's what we have. We can't
Right,
we
got
can't
you.
abandon the existing parliament. That's what we have running now. Go to the existing parliament with the results of this
Right,
process and
right,
let them vote. But remember, when you design the thing that way, the opposition is there in the negotiations. It's not the
right,
executive and Rowley and the team just telling
right.
everybody what to do. So you have to
Well,
do it
anyhow, they didn't support it, eh? This constitutional group didn't support it, right? The referendum. But so, Mr. Montano, I hope he has answered your question. I think he has. Dr. James has answered your question. He says there must be much more consultation and more intense, more inclusive, and you have to find ways to not just go through the emotions, but really make it and have the metrics, because that is he's an econometrician, which means he measuring things. I know that's what it means, measuring. So he will be able to take this and not just old talk and people just giving views, but actually be able to take it and measure it to make a determination. So it's a form of referendum, but not maybe
good,
how we
good data, so to say. You don't just
are.
get junk. You do an ordinary referendum, and 90% of the answer will perhaps be junk. You got to
That's what
get
they also, and that's one of the reasons I think they used and not to support it.
exactly. You just do it properly, and you won't get 90% of what you get will be sense. That's the whole
Yeah.
point.
Yeah. So I hope we answered the question. One of the things I want to bring up as we talking generally about the constitutional reform document that was prepared, I think this is a good point, but it had been made by Wooding before, and it's been moving in that direction. And then if you read the case law, which I tend to read up on, Privy Council decision. Privy Council decision. That's our final court of appeal still. The question of the savings provision, which of course meant that if a law was in existence at the time of independence and it went into the Republic Constitution in a different section, but it's a little different wording, but essentially it meant if it was there prior to becoming independent, even though it offended or infringed those basic human rights that you are enshrined in our Constitution, it is going to be a valid law. So what it's going to be valid, and we've seen that with the death penalty and the ways in which the Privy Council has done all its best because of its own policy position, its own views on it, in my respectful opinion, to ensure that that act never in reality can be implemented. So what this committee has recommended, and Wooding had recommended, is do away with that savings clause. A lot of other jurisdictions have done away with the savings clause. It had a purpose in the early days when we had no jurisprudence, when we were now building ourselves collectively as nations, new nations, and we didn't have our own local, as I say, indigenous provisions. We were a young, very young nation, and so therefore the need for certainty and direction perhaps was important to help us to find our ways. But 62 years later, there's no justification. However, they have said that what we must pay more attention to, and it is in our 1976 Constitution, the Section 13, which deals with even if a law is passes it's not an existing law thing. It's a law that you passed after 1962, right? And you got the 2/3 or 3/4 majority because some laws require that special majority in order to be made law. There's a Section 13 in our Constitution that says, I wrote it down so many times so I will remember to use the exact wording because I could never remember the wording. It says that Section 13 says that even if you are able to meet the requirements of the 2/3 or 3/4 majority, you still have to satisfy Section 13, and that is, the law would not be valid unless it is reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. And so what they pay a lot of attention to now in this document from the Constitutional Reform Group and in Wooding and going in the case law, obviously following that, is a question of proportionality. You have to weigh the rights of the individual against the rights of a state. Taking away someone's individual rights, you've got to weigh the impact of that and against the rights of a community. And they said there should be more robust provisions. Get rid of the savings clause. It served its purpose. We don't need it anymore. We don't need to have it anymore. Get rid of it, but go to Section 13 and make it much more robust and much more effective. I don't know if you looked at it. That's an important provision because I think we had a case with, the Achille Charles. Right,
Yeah.
but Charles, just for the listening audience, Achille Charles, in that remand, what the average time about a man spends in remand? I had looked at CSO figures. I don't want to exaggerate, but I know it's between 5 and 10 years. Imagine that. And remand doesn't mean, remand you waited to find out if you should stand trial, If you should stand trial, This is before you're waiting for a magistrate to tell you if there's enough evidence that the police collect for you to stand trial for him. This young man spent about 10 years in remand, waiting, and then that chief magistrate airs that whole bacchanal with who they decided that his matter had started, but you had to start it de novo again because it had not been completed. In any case, at the Privy Council level, they said the Bail Act that we have in Trinidad was passed in 1994. It was passed after 1962. It met the 2/3 or 2/3 majority requirement, and so the AG argued, well, it's good law. It's good law. The bottom line is that the Privy Council said that you have not convinced us that it met the Section 13 requirement. that as hard as you telling me how things are in Trinidad and moving, you have not addressed adequately the argument, the proportionality. So I think what they are saying now, in light of that case in particular, that now you're saying get rid of the savings clause, it's done its work. We need now to make sure that when our legislation requires a special majority, that the Section 13 provision is spelled out in more clarity and more robustly, so that the citizens can be sure that when it is made law and stands up, that it has stood up to that test of Section 13. Dr. James, are bored with that or what?
Not at all. And let me say that I have no argument about dispensing with the savings clause or any other vestige of colonial
I'm sure I know that.
lack of self-confidence.
True. So what did you have the last word? We had other things we could have talked about. They said something about the Auditor General. Just one thing I think it was important, and then I'll leave it to you. And they said things about the DPP, but we do have time. Important offices. We just don't have the time to look at the Auditor General, the Ombudsman, and the DPP. They did look at it, and they did make some general recommendations, which are not strong enough in my view, but we don't have time to look at it. But with 5 minutes left, if David, if you want to ask a question, Mr. Montano, if you want to ask a question, Trinidad and Tobago is not a democratic country. It has a democratic system. And nothing is independent. It's controlled by the Prime Minister. But I think Dr. James did a good job of telling me of a king and a prince. I think we heard that. I think he said to that. And I think he answered the question in the referendum. So with the party notes, and we don't have time to look at those other things, what would you like to say about this effort made by this group of people, apart from not having a proper representation, but having executive representation? What would you like to say about that document?
A very bad job. And I would say that the most important principle my communities have in mind is that between the central government and the THA and the citizen should lie the citizens' communities to create a massive buffer between a networking buffer between the individual and the might of the THA and the might of the central government. And their point is, given our history of authoritarianism, you better let's put that buffer in place. Otherwise, all the talk about individual rights and so on will be for the birds. Victimization and all those things will be practiced. But if you put it in place, citizens will be able to deploy their communities as a defense mechanism against authoritarianism on high. You couldn't want a sweeter way to understand what communities are really saying in Tobago. And I remind you, they say, that's what we think. And since we own at least this part of the country, you better listen to what we have to say.
Oh, Lord, Dr. James, I want to tell you, Dr. James, you were going so good. You were serious. You were going really good.
Well, that you is Trinidad, That you is not carrying Trinidad.
I wish you didn't separate us like that. Honestly, because I think what you're saying is extremely valid. Because, in fact, the document is spent very little time on Tobago. Extremely valid. And what I think you are saying, and I think I have learned, certainly, and I wish more people had commented, but I know David keeps telling me we have a big listening audience, and then they have Yahoo and they listen later and so on. I think what you are saying, you keep Tobago, but what you're saying, let's expand it out. What you're saying is if you have a proper structure that allows for a proper inclusion, for proper participation of the people in the decision making in Trinidad and Tobago, whatever different models are best suited to our particular history. But the basic premise is that if you do that, all other things will work themselves out. Is that?
Well, you are a great example of what Tobagonians expect our fellow citizens to be like in Trinidad. You can hear and learn and understand. We have, are we not? We can get what we only call kumbaya.
You know, you're a good teacher. No, I'm serious. I'm telling you, you're a good teacher because, you know, that paper really bothered me. But I didn't have time to be very honest. You know, I had a lot of other, you know, so I had to cover the kind of, you know, detailed study. I really didn't do the way I should have. So I did it in a very, not in a systematic way, rather looking at this, looking at that, which of course is probably what they would like you to do. But what you did, I said, no, worry to tell me about all I'm doing, you know. Don't worry to tell me about all I'm doing, you know. Until you get this part right, none of that matters. That's what you said, in a
Correct.
nutshell.
Correct is right.
Correct. That's what you said. Whether it's village in Tobago, which you're only talking about all the time, or our village in Trinidad, or however we want to do it, unless you get that right, the rest don't matter. And so when you started by saying it was a bad document and it was an executive document, I tried to be independent in my thinking and fair, and I think you have really justified and rationalized it very well.
We'd be happy to send you a copy of our community's views.
I'll be happy to receive it.
If David would give me an email address, we'd be happy to send it to you this evening or tomorrow.
What is this?
I will send you, I will send you my email address.
A pleasure always talking with you, Karen.
Yeah, we talk good. Poor David. David is like my little oracle. Poor David. David is my village council.
Absolutely.
I always try to put together some pertinent questions to ask Dr. James, but I don't have them together as yet. But I will send you my email address, and I will send you some of the what should I say, things that I would like to see happen too with
Maybe we can
lab.
have you, since we're talking constitutional reform, maybe I didn't have anybody lined up for next week, and maybe, you know, those other things could be discussed and we can flesh it out, because David's telling me I'm his warrior. I am a warrior. I am a warrior. He's true. I'm a warrior. You know, I'm a warrior. I fight for I fight for that. You know, you do have to put on I have to have a gun and an armor and so on, but have people like you. When I have people like you come on, then people learn and understand, and they will understand. It's not, I didn't bring you here to come and speak sing a party song. I brought you here to educate all of us as to what that document means. So I would love to have you back. And you wouldn't even have to send that. Matter of fact, you better send a document for me so I could read it.
Indeed, we will.
It's always a pleasure having you on, Professor.
Yeah, man. Oh, thanks for the invitation.
Thanks for coming. We really
wonderful session, Karen.
Thank you. Thank you. All right. Take care. Bye-bye.
Okay. Have a great evening, folks.
Bye-bye.
That's it for today's edition of Hard Talk. Very, very informative and very, very, very motivating with Professor James and